Tobago House of Assembly's Post-Executive Council media briefing for week ending October 20th, 2012. This week, Senior State Counsel Alvin Pascal joins Chief Secretary Orville London in a continued response to construction of the Agricultural Administrative Complex. But first, Infrastructure Secretary Hilton Sandy gives an update on the Orkinscure roundabout.
I would like to report that the paving works has been completed by Serum Brothers. It's a good job being done by Serum Brothers. And what you're going to know is the markings. Today, as I speak, the marking is supposed to commence today. But because of weather condition, I know that things might not happen. But we are hoping that within 8 days, that the markings and all the signage would be up on the roundabout. TNTech is also asked to replace the street lights that were there, so we have the lights putting at the roundabout. And after that, we will have the training is ongoing today, and Dr. Furlong is meeting with the police to discuss with the police and to give them some insight about the use of roundabouts in a general way, so the police will be up to speed as far as the roundabout is concerned. And what we have been doing, we in the division, our public relations officer, over the past week has been sending out to TT Post. We have sent out handouts on how to use the roundabout on all post box throughout Tobago. After the 8 days window of painting the roundabout, again I will give you the date. Soon after that, we will officially open the roundabout. It would not be out there too long to open. So by the end of the month, I'm hoping that things should close in. I'm not giving you a fixed date for the opening, but I'm just saying around the end of the month, we'll try to have it open, and which I will give the fixed date to the media. I want to just say here that at the press conference of the TOP, Mr. Jack made a statement about putting the roundabout in the center of a highway. That was part of a statement coming across, you know. So they're trying to still criticize the highway. And I'm not going to spar here, but I want to just say that the same way you could put traffic lights on a highway for its purpose, is the same way you can use a roundabout on a highway. And a highway definition is used, we call it a highway because a highway is to connect villages. You use it as a main connection to all villages going through a network. That's what you use it for. So the connection is made through that highway going, which we call the Claude Noel Highway. So I just wanted to let the public know that it's not a speed lane we put in non-collar highway. It is not for that. And highway is used for getting to connecting all villages in Tobago as we go along.
Mr. Sandy then spoke on the construction of the Charlottesville Mall.
As you know, MTS happened to be the project managers for the Division of Infrastructure and Public Utilities, charged with the responsibility to construct the Charlottesville Mall. And when we saw the article in the papers, we would have get in touch with our project manager to find out what was happening, because we gave no instruction to close the project, and no one else besides the THA can close the project. No one besides the THA, not even the EMA can close a project. There are rules and regulations in the country, how the EMA fashions. And EIA is for certain size of construction, and you have a CEC for certain size of construction. And as I said before, the responsibility of getting all permissions to construct the mall in Charlottesville is with our project managers and their agents. Because the architect and all who are connected to the program works with the MTS. MTS is our project manager for that program. I want to report today to the media and the people of Charlottesville that the project is continuing. The contractor is Towers Limited, and they will continue to construct the temporary facilities for the vendors' removal from the site, and we will continue the construction of the mini mall for Charlottesville. Any stoppage of that project has to come from the Tobago House of Assembly. We have not given such instructions, and the project is going to continue.
Senior State Counsel Alvin Pascal brought some legal clarification to the statement made by the Prime Minister.
The headlines, THA must return building in 20 years. A number of the national newspaper carried similar statements. The genesis of that came from a statement learned by the Honorable Prime Minister at the TOP's UNCPP platform in Tobago. I have given a fair amount of copies of this lease document out. I've left a copy with Mr. George this morning, Mr. George Leacock this morning, really. I operate with a full copy of the lease. Registered, stamp duty. This is the full document. It has the Appendix B to the document. Appendix B to the document. This document was sent to me by lawyers who prepared this document via scan on the internet. It didn't come in piece or parts. So therefore, this is the full and complete document that we have been working with at all times. Right? What the Prime Minister do was a little bit not in conformity with what lawyers do. Lawyers describe these type of actions as cardinal sins, because it is well said that you never ever pluck out of a legal document, especially a lease, and cite one clause, really. You see, because it could distort the whole process. A lease document should be read as a whole. Any lawyer, any judge coming to construe this document, he says, I would read the document or construe the document as a whole. So it is a cardinal sin. We describe that as a cardinal sin when any practitioner do act like that. And what the learned Prime Minister did is at page 7 of the office lease, a document that without doubt she had in her possession because she said somebody put it into her postbox. So she in fact had that document that they say they were not seeing for all these periods. It was in her possession because she referred to clause U, or what we call clause 3, subclause U of the office lease. The office lease is Annex B. It is the document which has all the terms and conditions of the building agreement. We call it the office lease. It is well set out in the document as the office lease Annex B. The learned Prime Minister went to page 7, and at subclause U, she said, she read these words: to yield up the demised premises with the lessor's fixtures and fitting therein. Now the lessor herein is the Milsherv Company. To yield up the demised premises with the lessor's fixtures and fitting therein at the expiration or sooner the termination of the said term in good and tenantable repair and condition. This is a little bit of legal language, but it's in English, and it says exactly what it means. It simply means that upon the expiry of the fixed term of 20 years, you must give back the building. So on the face of it, the Prime Minister is right when she reads out this, because every fixed term lease comes to an end, and the draftsman of these leases puts a clause in to say that upon the expiry, upon the 20 years, you must give back the building. So if that clause alone was read out, it will distort the whole, it distorts the whole arrangement if you read this clause alone. So more wiser counsels or more wiser lawyers know that whenever you see this in a lease, it is a standard clause in a lease, it is standard form in a lease. Wiser lawyers, when they see this, they say they have to go a few pages more into the lease, Because any lawyer seeing this, any experienced attorney seeing this, knows that there will be another clause following. And those who understand as conveyancers will know, without even looking into the document, that you look for one of two type of clause. It's either a right for renewal of the lease. You will see in that lease saying that if you kept the covenants and so, the said landlord will give the tenant another term of years. It might be for the same term of 20 years, might be the same term of 99 years, or 100 years, however it is. But there's always a clause in a lease after this clause which says that the landlord will give the tenant a renewed lease. And that happens in any building. If you have your own house where you have a lease, none of your landlord tells you to come and break down your house and go. He gives you a renewed lease. The other things that wise conveyancers or wise lawyers look for is the concept of the option to buy. In the Milshove arrangement, the lease that the attorney should be looking for is the option to buy. And that option is set out fully in the building lease, that same Annex B, at clause 5, subclause B, on page 8. Clause 5, subclause B, at page 8. And what that clause did there, it makes that clause that the Prime Minister read out there to be redundant, to be irrelevant, because this lease is saying to the tenant, which is the THA, that you have the right to buy. Now that the lease has expired, you have the right to buy it ready. And this clause tells you here, at any 3-year anniversary of the tenancy, so once the first 3 years has gone in this relation, the THA has the right to option to exercise to buy the property. And for every 3 years thereafter, so 3, 9, 12, 18, until the 20th. So this lease provides a right to buy, an option to buy the property given to the THA. And the mechanism for purchasing or calculating the cost of purchase, the cost of the building, is well set out at clause 5B, 2 and 3, Roman 2 and 3. It says here, the purchaser shall be deemed by the purchase shall be deemed by calculating the net present value of the total rental payment payable for the unexpired residue of the term hereby granted at the time of exercising the option. And it tells you when you go to exercise that option, you write to the landlord. So what the Prime Minister did by saying that by reading that clause, she gave half of the story. A half of the story that isn't important. The real story is in clause 5B, 1, 2, and 3. And if you want to take this a little further, you go back to the building lease, to the land lease. That's the lease where they said that we give it for $10 at 199 years. And in that, at clause I here, you would see, at clause 2I, here was the building lease says. This is the lease which just said. This is the lease which just said that we give the people away at $10 for 199 years. Here what it says. We are telling them that. That's it. THA who grant them the land is telling them this. To yield up, that is to give up the said lands at the expiration. That means at 199 years. You see, after the 199 years, we say you have to give up this lease. Or sooner determination. That is for any other reason that will cause the lease to expire, or to come to an end. Or the third one, which is relevant to this transaction, here what it says. Upon, listen to this carefully, upon the satisfaction by the lessor of the terms and conditions of the office lease, whichever is earlier. So it's saying that the land lease, which we give them for 199 years, will end when we do what we're supposed to do under the building lease. That is either buy within the option 3, 9, 12, and 18, or pay off at the end of 20 years. So this as the lease open, it tells you that the THA have the right, this property will be coming to them long before 199 years has expired. And here how it will happen. In the latter case, the lessor will execute, that is to sign a deed of surrender of the lease, which means to say the Milchurf people will sign a document, a lawyer's document called a deed of surrender. That is the document which you use to kill a lease. So I'm going to repeat it again. It doesn't matter whether the lease was 199 years. This lease will die at latest 20 years under this arrangement. And after 20 years, the whole property, which is land and building, comes back to the THA.
Chief Secretary Orville London said the THA is confident in the decision it made as he responded to the central government's decision to sue the THA.
I want us to recognize that this administration, we are very fortunate in that we have a senior state counsel with over 20 years experience in public law. And when we make decisions, we are guided by the advice of the senior state counsel, who will also be advised by senior counsel and his colleagues when he believes that he has an issue where he needs additional advice. And it is in that context that we have every confidence that the decisions which we made were decisions that were according to the laws of Trinidad and Tobago, and of course, according to the powers given to the Tobago House of Assembly under the Tobago House of Assembly Act. I want us all to bear in mind that any time there is a relationship between a local body and a central body, or between the Tobago House of Assembly and the central government, there are going to be issues where there is going to be disagreement. And it's very interesting to note, you know, despite all the hullabaloo, one will get the impression that this is the first time that the Tobago House of Assembly has been taken to court by the central government or vice versa. I got my people to start doing some research, just to start. And there have been at least 4 occasions where either the Assembly has taken the central government to court or the central government has taken the Assembly to court. In other words, and it started way back, even when we had the 1980 Act. Mr. Robinson was taken to court, well, not Mr. Robinson, because I'll come to that. The Tobago House of Assembly was taken to court in 1982 when the government took the Assembly to court. The Assembly took the government to court in 1984, I think twice in 1984. The Assembly triggered the Dispute Resolution Commission in 2000 and also started legal proceedings against the government in the same year, 2000. So I want us to recognize that the idea of there being disagreement on the interpretation of the powers of the Assembly or the control of the central government, that is something that has occurred on a number of occasions. In fact, between 1980 and 1996, it will have occurred on 3 occasions, and between 1996 and 2001 on 2 occasions. So this maybe is the longest period in the relationship between the Tobago House of Assembly and the central government that we actually have a situation where we have had no legal action. The difference between what transpired on those 5 occasions and what is transpiring now is that the focus was on the issue. The focus was not on politicizing. The focus was not on slandering. The focus was on the issue. And therefore, when you look at the litigation, it was a litigation between the Tobago House of Assembly and the central government. There were no aspersions cast on individuals who were taking decisions based on their interpretation of their powers under the Tobago House of Assembly Act. If during the discussion and during the action, any evidence was seen of personal, personal involvement, well, then so let it be. But to have a situation where at the beginning of a process, before any evidence is put forward, where you have a disagreement between the central government and the Tobago House of Assembly about either the powers of the Tobago House of Assembly or the control of the central government, something that has happened on a number of occasions in the past, and to allow that to create an environment where people's characters are being sullied in this manner, I think that is very unfortunate. This Assembly will continue to do what it has to do within the parameters of the law for the development of Tobago. We recognize that we have constraints, but we also recognize that we have certain powers. And therefore, using those powers, we have a responsibility to the people of Tobago. I want to just indicate that had it not been for the capacity and the ability and the commitment of this assembly to treat with issues in a manner that we can prioritize and determine how we can utilize the limited resources to the advantage of Tobagonians, a lot of what has happened in Tobago over the last 10 years would not have happened. I want to just draw your attention to the present situation and to ask yourself if we in the Tobago House of Assembly do not have a responsibility to do what is necessary so as to ensure that the instructions, like the instructions in the budget or whatever, are not going to instruct us as to what we should or should not do. In this budget for fiscal 2013, the Tobago House of Assembly asked for $10 million. And that $10 million was to continue a scholarship program. And the scholarship program, as you all are aware, is a program that has put scores, hundreds of Tobagonians through university. And a number of Tobagonians from disadvantaged parenthood did in fact benefit from that. The allocation this year was $200,000. You would have heard about the much vaunted youth program. Again, we asked for $20 million. And that program, of course, was to help those individuals who come out of university. We got $300,000. I was just looking at the allocation in relationship to my own division, the Office of the Chief Secretary. And all of us know the importance of energy and the fact that we in the Tobago House of Assembly recognize the importance of setting up an energy secretariat. And in order to ensure that we can set up this energy secretariat and that the energy secretariat will be in a position where it can treat with Tobago's development and Tobago playing a critical role in this entire process, we asked for $5 million. The total allocation was $200,000. Even, for example, that Bacalet Indoor Complex and Aquatic Stadium, for which the people of Tobago have been clamoring for many years, our total allocation this year was $1 million. I'm saying all of this to indicate that if we allow the allocations as put out in the budget documents to determine how we spend and what we spend it on, we'll be waiting decades for anything to happen in Tobago. But that does not make us reckless. We ensure that we operate within the parameters of the law. And that is why I have no problem, I have absolutely no problem with anything that is put in place to investigate or to treat with any decision made by the Assembly. Because what you noticed in those pieces of litigation between 1980 and 2000, some of them the Assembly lost. The Assembly won the first in 1982, it lost in 1984, it won in 1984, it won the Dispute Resolution Commission, and then the fifth one was undetermined in 2000. But what it did, if you look at the 1980 Act and the 1996 Act, some of the case law that came out of these cases actually informed the 1996 Tobago House of Assembly Act. So as far as I'm concerned, I think the timing of this situation here is ideal, because it allows us and maybe allows the court to determine under the 1996 Act how much power the Tobago House of Assembly really has. And if there is need to adjust the next act so as to ensure that the Tobago House of Assembly does have the authority. But what I know is that our actions would have been based on sound legal advice and based on our determination to ensure that the development of Tobago is not frustrated, but that we keep within the parameters of the law as we understand it.
Turning to World Food Day, the Chief Secretary complimented the farmers on their participation.
That I see World Food Day as both an end and a beginning, and an opportunity for us in Tobago to evaluate what has transpired in the past year, and then, of course, to move forward into the new year. And I think it is in that context that I really hope that the theme, this year's theme of cooperation, that theme is, of course, followed assiduously by our practitioners. Because when you have a small island like Tobago, you really need the level of cooperation among the various agencies if the objectives are to be achieved. And the display was quite impressive, but it cannot be seen as just simply an event. It has to be seen as an opportunity for us to evaluate what has happened and a catalyst for an even more effective response in the upcoming year.
Thank you for watching the Tobago House of Assembly's Post-Executive Council Media Briefing for week ending October 20th, 2012. For the Department of Information, I am Sophie Gill.